अपना कोई केस नहीं है, मगर जैसे विकलांग लोगों की संस्था या कोई NGO या DPO जैसे हम कहते हैं, वो एक पेटिशनर बनकर कोर्ट जा सकता है और कोर्ट से रिट के थ्रू, PIL की रिट के थ्रू कोई कानून को बेहतर करने के लिए या अमेंड करने के लिए या कुछ अगर गलत हो रहा है उसे ठीक करने के लिए केस फाइल कर सकता है। उसमें बहुत जल्दी रेमेडी मिलती है। जैसे एक केस आपने अभी सुप्रीम कोर्ट में फाइल किया था, हाई कोर्ट में, दिल्ली हाई कोर्ट में फाइल किया था। एडवर्टीजमेंट निकला था 43
there were 43 posts, 1,500 vacancies.
तो 43 पोस्ट का वो एडवर्टीजमेंट निकला था और उन्होंने उसमें वो डिसेबिलिटी कैटेगरीज एडवर्टाइज नहीं की थी जो उनकी लिस्ट में थी, तो उसके खिलाफ पब्लिक इंटरेस्ट फाइल किया, तो 3 दिन के अंदर हमको वो रेमेडी मिली। और सुप्रीम कोर्ट में भी आप इसी के थ्रू जा सकते हैं, आर्टिकल 136 में।
So we can skip the next lecture. So now to some examples of cases that we have done. In employment, a recent judgment in March was quite well received by the disability community. It involved the largest public sector employer, which is the Railways. The case was filed as a PIL in 2005 by the All India Confederation of the Blind. And this is one disabled persons organization that is very, very active in legal advocacy and takes up issues on their own with great enthusiasm. And I really would love to see that more disabled persons organizations all over India are equally active in terms of the legal advocacy route. In any case, one of the unique things in this particular petition, the railways were not implementing 3% reservation. It's a huge employment force. Right before the Delhi High Court, they were directed to calculate their backlog going back to 1996. And the court, in fact, appointed a registrar of the High Court on a special basis to oversee the process of calculating the backlog, to make sure that the railway did not fudge their numbers. And the backlog came out to 4,100 posts for disabled persons in Group A and C and D. And the railways were so unhappy with this outcome that they actually changed their lawyer. And that lawyer since then does not talk to me very much in the High Court, unfortunately. Not that anything different happened with the successive lawyer, because after the court directed the railways to conduct a special recruitment drive for 4,100 persons with disabilities, the railways then took a new excuse or approach, which was that there were many technical and engineering jobs which they could not fill with persons with disabilities because of issues of safety. Railways running trains on tracks and so on. And we opposed that move because many of the jobs that were in the backlog were in fact of technical and engineering jobs. And it turns out that the very same central government list of jobs identified as suitable for persons with disabilities includes technical and engineering jobs. And we showed that list to the government, to the court, and Justice Sikri came out with a lovely and detailed judgment just last March, directing the railways to fulfill within 6 months the entire backlog of posts and include persons with disabilities in the technical and engineering posts as well. I just mentioned the next case, the All India Confederation of the Blind versus the Delhi Subordinate Services Selection Board. I think what helps when we take these cases to the court gets aware and even educated on what the provisions of disability law are. Because the very same